In India, writ petitions are legal remedies that can be sought from the High Courts and the Supreme Court under Article 226 and Article 32 of the Constitution, respectively. Different types of writs are available to address specific situations. Here are the common types of writs and a general overview of the procedure to file a writ petition. Common types of writs. 1. Habeas Corpus. This writ is used to protect an individual's right to personal liberty. It seeks to ensure that a person is not unlawfully detained or imprisoned. When someone believes that they or someone else is being held in custody without proper legal justification, a habeas corpus writ can be filed to challenge the detention and secure the person's release. 2. Mandamus. A mandamus writ is issued by the court to compel a public official or authority to perform a legal duty that they are obligated to perform. It is used to ensure that public officials or bodies do not neglect their responsibilities or misuse their powers. 3. Certiorari. This writ is issued to quash the decisions of lower courts, tribunals, or administrative bodies that have acted beyond their jurisdiction or in violation of natural justice. It's used to correct legal errors in judgments. 4. Prohibition. A prohibition writ is sought to prevent a lower court or tribunal from exceeding its jurisdiction or acting in excess of its authority. It is intended to stop proceedings that are unlawfully taking place in lower courts. 5. Quo Warranto. Quo Warranto means, by what authority? This writ is used to challenge the right or authority of a person holding a public office. It aims to ensure that public offices are held by individuals who are legally entitled to hold them. Article 32, Right to Constitutional Remedies. Article 32 of the Indian Constitution provides the right to move directly to the Supreme Court for the enforcement of fundamental rights. While not a specific writ, Article 32 allows individuals to directly approach the Supreme Court to seek remedies for fundamental rights violations. Procedure to file a writ petition. Identify the appropriate court. Determine whether your case falls under the jurisdiction of a High Court, Article 226, or the Supreme Court, Article 32. Generally, High Courts deal with state-level matters, while the Supreme Court handles issues of national importance or those involving a question of law. Drafting the petition. Prepare a written petition that outlines the facts of your case, the violation of your rights, and the relief you are seeking. The petition should be clear, concise, and supported by relevant documents and evidence. Choose the relevant writ. Identify the appropriate type of writ that aligns with the nature of your case. This will determine the specific relief you are seeking. Engage legal counsel. While it's possible to file a writ petition on your own, pro se, it's recommended to seek legal counsel for better understanding of the legal procedures and to ensure the petition is well drafted. Filing the petition. Submit the petition along with supporting documents to the respective court's registry. There might be a filing fee associated with this step. Preliminary scrutiny. The court's registry will review the petition for any procedural issues or deficiencies. If everything is in order, the petition will be listed for hearing. Hearing. The court will schedule a hearing date where your case will be presented before a judge. You or your lawyer will present your arguments, and the respondent, the party you're challenging, will respond. Orders and judgments. The court will consider the arguments and evidence presented and will issue appropriate orders or judgments. The court can grant the requested relief, dismiss the petition, or provide other remedies. Appeals. If dissatisfied with the court's decision, you might have the option to appeal to a higher court, depending on the circumstances and applicable laws. Remember, the specific procedure and requirements may vary based on the court, jurisdiction, and the nature of your case. It's advisable to consult legal experts or resources specific to your jurisdiction for accurate and up-to-date information.